Welcome back to part three of this webinar. We are very excited. This is the last and final part.
Hi, I'm Ruben Gottlieb. I'm here with my partner, Hector Chichoni, and we're going to be talking in this third phase about planning, pre-immigration planning, which we've led up to it up till now, and now we're going to implement it for all of you. Yes. So now we're going to talk about certain ways prior to coming to the United States. You're speaking to Hector how to get in, but when speaking to me, there's certain things we're going to want to do before you get here that will help you once you're here from a tax standpoint. So what are they? You can form certain irrevocable trusts prior to getting here. You can gift assets outside the United States. If you're giving assets in the United States, keep in mind that you can only give $16,000 of U.S. situs assets, 16. However, you can gift any amount as a non-U.S. individual of intangible assets. So if you want to gift stock in U.S. companies, you can gift any amount. Doesn't matter. You're not limited by the 16,000, but you want to make any gifts that you're going to make prior to getting here. You want to accelerate income because obviously we can't tax you if you're not a U.S. individual. The only way we, the United States, can tax you is if you're a U.S. individual, as we've been discussing, or you have assets here. Other than that, we have no jurisdiction to tax you. So if you give it away before you get here, or you accelerate by selling an asset and receiving the money, and there's even one letter ruling from the IRS, I think it goes back to the early 1960s, that if you sell something and you take back a promissory note on installments, those installments still won't be included in your income. So you gift assets, you sell assets, you accelerate income. You're entitled to a commission. Get it before you get here. By the same token, you can use deductions globally that you have. So if you have deductions that you can use once you get here, hold off. Don't do it until you become a U.S. resident for income tax purposes. There's a number of things you can do. Similarly, insurance, life insurance. It's a very important part of estate planning. And life insurance in a non-resident, even from a U.S. company, is not subject to estate tax. But once you get here, it is. So I had a client many years ago. He came here and he was in life insurance. I'm talking about life insurance now. I'm sorry. Life insurance was what he did. He was a very wealthy man. And in his home country, he sold life insurance. And he had about $7 million of life insurance back in the day when it wasn't $15 million, but it was $2.5 million. And he had about $7 million just of income, of life insurance. So I told him prior to getting here, I said, let's put that in an irrevocable trust. And under U.S. law, you have to outlive the transfer by 3 years so that it's not part of your estate. And I think he was 65 or 67 back then. He says, you guarantee I'm going to live 3 years? And I said, I tell you what, I do. And he's 90. He just turned 90 this year. But I also guarantee that if you don't do it, it will definitely be part of your estate. So we have to do it. So now he turned 90. He took his whole family to Mexico. He wasn't from Mexico, but on a cruise. And he thinks I'm a genius, and I don't tell him otherwise. But got to do beforehand. Any number of one of these things you need to do beforehand. And really, you've got to take into consideration if you have a foreign account, you come to the United States and you have a foreign bank account or accounts that on any given day during the year equal or exceed $10,000, there's reports you have to file, FBARs. It's not a tax, but the failure to file it will create a penalty. If you're gifting to a U.S. individual $100,000 or more, they have a report to file. It's not a tax, but once again, the failure to do it creates a penalty. So I had a client once, and I said, you're receiving money from your father from abroad. You're U.S. now. Have you been declaring it? Does your accountant know about this? And she says, no, but I don't get much. No es mucho, un poquitico, no es mucho. I said, well, how no mucho is it? And she goes, $100,000. And I'm thinking, I wish I could consider that not a lot annually. But I said, well, it's over 100,000. You need to report it, and you needed to have reported it. So there are certain things you've got to take in consideration once you become a U.S. resident slash domiciliary slash citizen, both from a reporting standpoint and from a tax standpoint, that you didn't have to worry about.
It's interesting, if I may add something,
Yeah, no,
that a lot of people, I mean, it's very common and very normal, do not know the law of the United States, and they want to come to the United States. They were seeking, peace, tranquility, even kill lives and all of that. And then, but again, there are consequences. For example, there might be, and I ask you right now, limitations if you are, let's say, have a non-immigrant visa. Can you be a trustee, for example? Can you of a trust? Things they have to do. Can you be a beneficiary of a trust? And what are some, for example, death taxes and how that in itself, you have to have a combination of a lawyer, an immigration lawyer, and a tax lawyer, somebody who that gives and states. I mean, that's for sure.
So that's a very good question. If you're a non-U.S. individual, or if your surviving spouse is a non-U.S. individual, let's say you are, but your surviving spouse is not a U.S. citizen, maybe only a resident, then you have to do what's called a qualified domestic trust within your estate planning documents, which means there has to be a U.S. individual or institution. And if your estate's over $2 million, it has to be an institution. Your spouse can, for you to get the marital deduction, your spouse can get the income, but any withdrawal of principal, they have to pay the tax on. And the fear is that they'll go back home to their city of citizen, their country of citizenship, and we will never get the tax. So that's the theory behind it. Now, if during the course of the surviving spouse's life, they become a citizen, then you can just rely on the normal Q-tip, you don't have to do the qualified domestic trust. You can just disregard that. But it's important to be in there. Now, if the person is not U.S. and they form a trust using U.S. law, let me back up. To have a domestic trust, you have to have two things. And this is good preparation for me because I'll be speaking on this next week in my class. You have to have two things. You have to have U.S. law that's applicable. Florida law has to apply. The District of Columbia, Montana, any law of the United States or districts have to apply. And you have to have a U.S. individual or institution that has all major decision-making for that trust. If you have both, you have a U.S. trust. And if you have a U.S. trust, wherever it earns income, it's taxed globally as well. If you don't have both, then by definition, you don't have a domestic trust, you have a foreign trust. So a lot of times what we'll do is we'll have a Florida trust, Florida law, and the trustee will be the grantor themselves, the settler themselves, and they're not U.S. So it becomes a foreign grantor trust typically. And so it is only taxed on what it earns in the United States. That being said, when it flips and the settler or grantor dies, and now the beneficiaries may or may not be U.S., what do you do? So you've got to decide who's going to be the trustee with regard to which beneficiaries, because you may want to keep it as a foreign trust for non-U.S. beneficiaries, but you may want a U.S. trust for U.S. beneficiaries because otherwise they're going to have reporting for non-U.S. assets. So there's things to do. You've got offshore companies. You may want to check the box, file a Form 8832 as a disregarded entity. But once that's done, it becomes taxable as a liquidation. So to the extent you can do that, the settler grantor should do that prior to death, and certainly with foreign assets. So they don't have to, when the U.S. individual inherits it, they inherit it as it's already been liquidated. And since they don't pay capital gains to foreign individual, there's no U.S. taxes. So there's certain things that can be done. I know I'm throwing
right
there.
No. But this is important because, I mean, again, it requires to be very sophisticated. I mean, I know that the United States is a very attractive place. We all know that. But there is also laws that, you have to be aware. And the only way to be informed and aware is to have an immigration and a tax lawyer and a give estate and tax, because it is impossible to follow all these laws unless somebody can resume them for you, brief them for you, and this is typical. Otherwise, the effects could be very consequential, and it's not so much for you, especially if you are later on in life. It's just for the people, your descendants, your children and your grandchildren, and so on and so forth.
And just, by way of background, it does change constantly. In a previous life, I was, and Hector knows this, the Associate General Counsel of the Immigration Service in Washington. That was over 100 years ago. But the laws in immigration have changed so drastically that I would never even attempt to do an E and H and L residency.
They do the same thing with tax. Yeah, the same thing with taxes. People resort to many. But again, I love the fact that when you describe, the issue of having a U.S. trust and not having a U.S. trust, and the thing, that in itself, sometimes people seek the stability of American law. Well, but there are also consequences. Yeah, the issue is pretty stable, keeps changing, and if there is something stable right now, is the law that the courts be able to hold. But that's another story. Anyway, I think
that stable is the instability of the laws.
Absolutely. Okay, this concludes part 3 and the final part of our webinar. We hope that you have enjoyed it and it's been informative to you. I am Hector Chichoni with Ruben Gottlieb. We both are immigration and tax attorneys. If you have any questions, please feel free to contact us. Again, thank you for listening to this, and we hope that to see you again in further webinars.